Let us quickly look into what are we going to learn: introduction, meaning, significance, definitions, applicability, and preventive measures as part of this module. Now, if you are learning this session by sitting along with some of your friends, you can share the knowledge with the person sitting next to you about whatever you know about prevention of sexual harassment at workplace. Thereafter, you can allow 2 minutes for your friends who are sitting next to you so that they can share their knowledge and you can listen to them. If we look at the history of mankind, sexual harassment of women at workplace is not new to the human society. It is as old as the history of mankind. Its implication at workplace has received attention during the recent time, but otherwise the practice by itself is quite old. It was only in the year 1997 a case come up before the Supreme Court of India, which is popularly known as Vishaka versus State of Rajasthan. When this case came before the Supreme Court of India, the Supreme Court of India was shocked to know that there are no clear-cut preventive measures in our country to prevent sexual harassment of women at workplace. Therefore, prior to 1997, there was only one section in the Indian Penal Code, which is Section 509, and that had very limited application in dealing with the prevention of sexual harassment at workplace, most probably due to lack of awareness on the part of general public. Moreover, prior to the year 1997, that is prior to the judgment of Vishaka case in Supreme Court, it was not the responsibility of employers to create harassment-free workplace, and therefore, if there is a harassment at workplace, then employers were not held responsible. Then from 1997 till the year 2013, that is approximately for about 17 years, there were no legislations or there were no law enacted by either state governments or by the Parliament of India, and the guidelines given in the 1997 judgment of Vishaka case were taking care of the protection of women at workplace from the harassment, sexual harassment. Then in the year 2013, the Parliament of India passed a historical legislation which is called as the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. For the sake of clarity, you can call it as Posh Act. Posh stands for Prevention of Sexual Harassment. This act came into effect from 9th December 2013. Now, what are the salient features of this act? It protects women at workplace from sexual harassment. Workplace has been widely defined under this act, and workplace also includes the dwelling house in respect of domestic workers. You know, domestic worker essentially means someone who works in a dwelling house. For example, your maid servant. Okay, even if a maid servant is subjected to harassment in the dwelling place or the place where she works in someone's house, that becomes a workplace for her, and she can take punitive action and prosecute the offenders. It does not provide similar protection to men or third gender persons. please understand, Posh Act protects only women from sexual harassment. If a man or a third gender person is sexually harassed at workplace, then this act is silent on that. It does not provide any protective measures. Few more aspects of this act are here. Women at workplace may be an employee, she may be a visitor, she may be a customer, she may be a contractor, or she may be any other place. But the question is whether the place is your workplace. As long as the act of sexual harassment takes place at your workplace, as an employer, you are responsible for protecting that woman by providing a harassment-free workplace. Harasser may be a man or woman. Please understand, under this Act 2013, an affected person or a victim can be only a woman, whereas a harasser or a culprit can be a man or a woman. It means even a woman can be a harasser under this Act. Sexual harassment is widely defined to include several unwelcome behaviors under this Act. Discuss what are those acts later on. Organizations have to frame the policy for prevention of sexual harassment at workplace. Organizations and district administration have to form committees to deal with harassment cases. Organizations and district administrations have to implement the recommendations of this harassment prevention committee. Organizations and government have to take up awareness and training programs for its implementation. Organizations and government have to publish the statistics in annual report about post cases. Organizations have to submit annual returns to the government. So in most of these points, I have mentioned organizations and government. What this really means is any workplaces which are having 10 or more employees. Not necessarily all these employees have got to be women. Even if you do not have a single female employee, still if your organization is employing 10 or more people in your organization, whether they are women or men, it is immaterial. If your organization is employing 10 or more people, then as an employer, we are required to form a sexual harassment prevention committee in your organization. That committee should be headed by a senior female employee. Wherever the number of employees are less than 10, then if there is a case of sexual harassment in that organization, naturally there will be no sexual harassment prevention committee in such small organization. So the affected female employee or the affected woman at that workplace will lodge her complaint to the district administration, that is deputy commissioner's office or deputy collector's office in the respective district, which will have a harassment prevention committee, and that district administration office will handle that case according to this Posh Act 2013. This act provides for confidentiality of the sexual harassment cases. So any information the sexual harassment prevention committee comes across about these cases, utmost confidentiality has to be maintained, and the details of the cases, particularly the information about the victims or the information about the offenders, should not be revealed to anybody. Guidance, assistance, and protection to the victim to lodge the complaint. Once a committee is formed, in any organization to prevent sexual harassment. Other departments like administration department or HR department or production department, they should not interfere in dealing with the sexual harassment cases. Any complaints received by a manager, supervisor, or anyone for that matter should be directly sent to the Sexual Harassment Prevention Committee. Conciliation as an option to the victim to amicably settle the matter. Let us say a case of sexual harassment has already been reported and the matter is before the Sexual Harassment Prevention Committee. At this initial stage itself, if the victim makes a request to the committee by saying that she doesn't want to proceed with the inquiry and punishment to the harasser, then the committee can look for a conciliatory approach wherein the accuser will tender an apology not to harass the victim anymore, and the victim will forgive the accuser. Okay, but please remember the option of conciliation has to be exercised only by the victim, and it has to be exercised in the beginning of the case and not after the matter is inquired into. This act also provides for punishment to the harasser as per the service rules if he is found guilty by the post committee. Once a complaint is received, the post committee will conduct the inquiry by calling upon the witnesses and documentary evidence from both the sides. Based on the witnesses' testimony as well as the documentary proof provided by the victim as well as the harasser, the committee comes to the conclusion whether the allegations of sexual harassment are proved or not. If the allegations of sexual harassment are proved, then the committee will also recommend punishment to be imposed on the harasser. Okay, so please remember the duties of a committee is not just confined to investigating the allegation. It is also empowered with determining the quantum of punishment to be imposed upon the harasser. Court shall not generally interfere with the quantum of punishment determined by the post committee unless the post committee has not followed the standard procedure of principles of natural justice. A domestic inquiry is not required to be conducted if the harasser is already found guilty by the post committee. In the post committee, adequate number of female members should be there. For example, always the chairperson of the post committee should invariably be a woman, and as far as possible, a women employee holding a senior position in the organization. Then, at least half of the members should also be women. Let us assume that there is a chairperson and there are 3 members. So out of these 3 members, at least 2 should be female members plus chairman. Or let us say if there are 4 members, then there is already a chairperson plus another 2 members shall be female members in the committee. In the post committee, there should also be a member from non-governmental organization or voluntary organization as an external member to be included in the committee. Generally, the advocates are not allowed to represent the parties in the post committees. Initiating criminal action if harasser is an outsider. Now, I already told you if an harasser is found guilty after the inquiry is conducted, then he has to be punished as per the service rules. So as per the service rules, you cannot hang him, you cannot imprison him. Service rules can tell you the minimum punishment of warning letter or the maximum punishment of dismissal from service. So as per service rules, you can give any of these punishments like dismissal or reduction in the salary or demotion from a higher rank to lower rank, or the lowest punishment could be the warning letter or caution letter. Okay. Now, if the harasser is not your employee, then as an employer, how are you going to punish him in order to give justice to the victim? Therefore, if the harasser is not an employee of your organization and he is rather an outsider, then the action has to be initiated against him under the Indian Penal Code so that he can be prosecuted in a court of law and punished by the court of law. But this law is quite well structured. Just because there is an act to protect the women from sexual harassment at workplace, no woman can take advantage of it and make false complaints. Or in order to play the office politics, nobody can give false evidence under this act just to fix someone you don't like. If such a thing happens, that is either making false complaints under this act or giving false evidence under this act, these are going to be considered as misconduct under service rules. And if the Posh committee comes to the conclusion that the complainant had made false complaint or the witnesses have given false evidence, then such false accusations or evidence can be treated as misconduct under service rules of the company, and such false complainants or such false witnesses can be charge sheeted and proceeded with as per the service rules for imposing penalty in the organization. Then this act also provides for interim relief to the victim like paid leave or transfer by the Posh committee. Let us say the victim has lodged a complaint and the inquiry is still on, it is not yet over. During this period, if the Posh committee comes to the conclusion that the victim has suffered a lot due to this harassment, and if a victim makes a request, then the Posh committee can recommend to the employer to sanction her paid leave up to 3 months pending inquiry. Inquiry is still going on. Apart from paid leave, in case the victim requests for a transfer, transfer may also be recommended by the Posh committee to the employer. So here you have to understand these interim relief will be determined and recommended by the Posh committee to the employer. Finally, the employer is duty bound to follow the recommendations given by Posh committee. Okay. But in this transfer, the victim can either seek her own transfer or seeking transfer is inconvenient to the victim. She can even request the Posh committee to transfer the harasser from that place to some other place so that the victim and harasser need not have to work in the same place again. This act also provides for payment of monetary compensation to the victim after the inquiry if the committee comes to the conclusion that victim has suffered monetary losses due to the act of sexual harassment. So what is this sexual harassment all about anyway? Let us now see how the act of sexual harassment is defined under this act. Unsolicited behavior of a person with a woman at workplace which is sexual in nature. And such behavior is not acceptable to the woman. Now here, what is the meaning of unsolicited behavior of a person with a woman at workplace which is sexual in nature? Now, unsolicited behavior of a person does not mean male, because right in the beginning I said a harasser can be a male or female. So therefore here person means person can be a male or female. A harasser can be male or female. Okay. With a woman, so the victim is only a woman, that's why the word woman is used. And this act of sexual harassment should have taken place or should be taking place at a workplace. And this very act of sexual harassment is sexual in nature, and such a behavior is not acceptable to the women. So, okay, if these conditions are met, then it is called as sexual harassment. What is unsolicited behavior of sexual nature? Section 2N and Section 3.2 of Posh Act defines what is unsolicited behavior of sexual nature as under. Physical contact or advances by the harasser to the victim. Demand or request for sexual favors by the harasser from the victim. Making sexually colored remarks by the harasser. Showing pornography or any other unwelcome physical, verbal or non-verbal conduct of sexual nature to a woman at workplace by the harasser. So all these behaviors or any of these behaviors on the part of harasser towards a woman at workplace amounts to sexual harassment at workplace. Then further definition of sexual harassment at workplace. If the act of sexual harassment is coupled with implied or explicit promise of preferential treatment in employment, or if the act of sexual harassment is coupled with implied or explicit threat of detrimental treatment in her employment. Implied or explicit threat about her present or future employment status. Interference with her work, or creating an intimidating or offensive or hostile work environment for her, or humiliating treatment likely to affect her health or safety. Okay, all these behavior constitutes sexual harassment at workplace. Please understand, implied or explicit promise of preferential treatment. Let us say harasser says, if you listen to me by providing sexual favors, either I will increase your salary or I will give you promotion, or let us say I will transfer you to the place of your choice. This is the preferential treatment. Or implied or explicit threat of detrimental treatment. Here he is threatening, if you don't listen to me, either I will not give you promotion or I will not give you salary increment, or I will transfer you to a difficult place, or let us say I am going to give you charge sheet on flimsy grounds. Okay. Third aspect is implied or explicit threat about her present or future employment status. Fourth, interference with her work in any other manner, or creating an intimidating or threatening environment at workplace, or offensive or hostile work environment for her, or humiliating treatment likely to affect her health or safety. Here, health can be both physical and mental health. So all these behaviors or any of these behaviors will also amount to sexual harassment at workplace. A few more important things you all need to understand about sexual harassment at workplace is who is an aggrieved woman. An aggrieved woman is a victim here. The word victim is not used in the act. Rather, the words aggrieved woman is used to mean the victim. Oh, aggrieved woman means a woman of any age who alleged to have been subjected to sexual harassment by the respondent. So here harasser is also not called as harasser. He is termed here as respondent. She is a harassed woman or victim. Protection under this act is available only to women. Aggrieved women need not have to be your company employee. A female visitor, a consultant, female consultant, a female customer, a female contractor, or any woman for that matter who is at your workplace can be a aggrieved woman if she is subjected to sexual harassment at that workplace. An employee is defined under this act as a trainee, a probationer, a contract worker, an apprentice, a supervisor, a managerial employee. Okay. So even the definition of trainee is quite exhaustive. Employer means anyone who's the head of the department or head of branch, head of unit, head of undertaking, who has ultimate control over the supervision and management of the organization. He is defined as an employer, so he is responsible for forming the committee and overseeing the activities of the committee and accepting and implementing the recommendation of the committee. Here, one more thing you all need to know is, I told you that if your organization is employing more than 10 persons, then you have to form a committee. Now, organization can be a small branch. Let us say in a bank, there are more than 1,000 branches. So each of these branches by themselves is an organization under this act. So all the branches which are having 10 or more workers will have to form individual sexual harassment prevention committees. I told you respondent under this act is nothing but this thing, harasser. Okay. So he is now nothing but an harasser. But under this act, respondent can also be a woman. A respondent need not have to be your employee only. Respondent may be your customer. Respondent could be your supplier. Respondent could be your consultant. Respondent could be your contractor or your visitor, or he could be any other male who was at your workplace and who was accused of being a harasser. The definition of workplace has also been widely defined under this act. Look here, workplace includes factories, mines, plantations, shops, commercial establishments, hospitals, educational institutions, sports facilities, places where women employ travel on duty, say a client location or a company arranged vehicle, charitable organizations, and even the dwelling place or a dwelling house. So any of these or all of this can be workplace as defined under this act. So as an organization, why at all you should prevent sexual harassment at workplace? How are you going to benefit? To comply with the law and to avoid prosecution by the government, you should protect the women by preventing them from sexual harassment at workplace. To promote harassment-free workplace, you should create a harassment-free workplace. To protect women at workplace, you should promote harassment-free workplace. To reduce employee attrition, see, if your workplace is known for sexual harassment, then no person would like to work in such a organization of disrepute. Therefore, in order to reduce the employee turnover, you should create a harassment-free workplace. To avoid court cases and litigations arising out of sexual harassment cases, you need to be harassment-free workplace. To become a best employer, you need to be a harassment-free workplace. So this act is applicable to all the workplaces, including if your organization has 10 or more employees, formation of internal complaints committee is compulsory. Internal complaints committee is nothing but the harassment prevention committee, which is formed within your organization. If your organization has 10 or more employees, so these 10 or more employees need not have to be female employees. Even if all of them are male employees, still you have to form internal complaints committee. If your organization has less than 10 employees, then complaints can be made to local complaints committee at the deputy commissioner's office or in district magistrate's office. If the complaint is against the employer, it has to be made to LCC and not ICC. So irrespective of the size of your organization, let us assume that your organization has more than 10 employees or say 1,000 employees, and your organization naturally has an internal complaints committee. Even then, if the respondent is an employer by himself, that is the head of the institution himself, then in such cases, the complaint has to be made to the local complaints committee located in the deputy commissioner's office or deputy collector's office, and not to the internal complaints committee of the organization. If internal complaints committee is not formed, then all the complaints have to be made to local complaints committee. For whatever reason, let us say your organization has not formed the internal complaints committee, or initially it may have been formed, but it has not been continued. So as of now, there is no internal complaints committee in your organization. So in all such situations, any complaints of sexual harassment has to be referred directly to the local complaints committee, which is in the district administration office of the respective districts. If complainant is a domestic worker, then the complaint has to be invariably made to local complaints committee only and not to the internal complaints committee. Now, this exercise we could have done, but for want of time, I'm skipping this exercise and let us move on to the next topic. If you have understood whatever we have been discussing during the past 45 minutes, then you can take this test. Prepare and publish harassment prevention policy for your organization. Whether your organization has already prepared and published an harassment prevention policy for your organization. And if you have not prepared, please do so from tomorrow itself. Second thing, as an employer or organization, the measure that you have to take, second measure is create awareness against prevention of sexual harassment by issuing circulars, posters, seminars, workshops, and other learning methods. As an employer, the third thing that you should do is form internal complaints committee if you have not already formed, and publish the details of chairperson and members of the internal complaints committee to the benefit of all your employees. Fourth point, provide training to internal complaints chairman committee's chairperson and the members. There are a few more measures. Provide necessary facilities for the internal complaints committee to function or to carry out its responsibilities. Implement the recommendation of internal complaints committee. Let us say the internal complaints committee meets, inquires into the allegations or complaints of sexual harassment and makes recommendation either not to take any action against the respondent or to take action against the respondent, plus it may also recommend some interim relief to the victim like paid leave or let us say transfer from one place to another place. So whatever recommendation the internal complaints committee gives, these recommendations need to be implemented. Third point, publish the statistics of the complaints in annual report of the company. So once in a year, all the companies in India publish what is called annual report, which is a statutory requirement under the Companies Act. So in that statutory report, you also mention a paragraph or two paragraphs about various measures you have taken about the sexual harassment prevention. If there are any cases reported, mention those cases. And if you have taken any action, mention about the action that you have taken. Then submit annual returns to the government. So in the Deputy Commissioner's office, the companies will have to, or the organizations will have to submit annual returns in prescribed format about various cases they have received and the actions they have taken. Under this act, the government is endowed with the duties to monitor the implementation and maintain database of the cases. The government is also required to give wide publicity about Posh Act to create awareness among public. It has the power to call for information or conduct inspection about harassment cases in various organizations. So government, if it wants, it can seek any information from your organization, or it can even inspect your organization to see whether you have created a harassment-free workplace. Then government can make rules under this act. So already under this act, both central government as well as the state governments, for example, in Karnataka, government of Karnataka has made rules. Central government had the power during the first 2 years to remove any difficulties by giving clarification, which is over by 2015. Now they no more this thing, entertain this power. Okay, in case you have got time, look at these 1 or 2 cases to understand and decide. Mr. Denny, a production supervisor in the assembly line, has complained to the HR department that her manager, Mr. Ankit, took her for a picnic to Goa and had sexual intercourse with her in a hotel after making her drink Pepsi mixed with sedatives. Now, if this is the complaint you have received, as a member of Posh committee or as a chairperson of Posh committee, what action you are going to take? Does it come under the power of Posh Act to deal with? If not, what advice you are going to give to Denny? See, here we can sit on arguments whether Denny is wrong or Ankit was wrong. Why did Denny accompany Ankit to Goa? All that. But whether the act of sexual intercourse without her consent is considered as sexual harassment at workplace or not. If you go back to the definition of sexual harassment at workplace, this act of sexual harassment will not come under the definition of sexual harassment at workplace. Why? Because such act is considered as an offense or criminal offense. It amounts to nothing but rape. So this has to be handled under the Indian Penal Code and not under the prevention of sexual harassment at workplace. Another example here, Mrs. Rashmi, HR manager, has complained to one of the members of post committee that company car driver Mr. Sujit is forcing her to marry him, even though she has turned down his proposal almost a year ago. So this is the complaint you have received as a post committee. Now, what are you going to do with this complaint? Are you going to entertain this complaint? If so, why? Are you going to reject the complaint of Rashmi? If so, why? First question you have to see is whether this act of forcing someone to marry him against her wish amounts to sexual harassment at workplace. Again, go back to the definition of this act and see whether the definition of sexual harassment at workplace covers an act of Sujit wherein he is forcing a female employee to marry him. This is our last slide. For want of time, we want to conclude here. Ms. Ninja, marketing executive, has alleged that one of the company customers, Ms. Rona Chuk, keeps sending her pornographic videos through WhatsApp even though she has not asked for it. Now here, what you need to understand, Nija is marketing executive and she's your employee, your marketing executive. And she alleges that one of the company customers, so this guy, the respondent here, is not your company employee. He is also not your supplier or anybody. He is a customer who avails your company service or who buys your products. His name is Mr. Ronaju. So he keeps sending her pornographic videos through WhatsApp, even though she has not asked for it. Now, whether the act of sending pornographic videos by a male to a female, okay, amounts to sexual harassment at workplace. This is what you need to decide. And if you think this amounts to sexual harassment at workplace, you have to think, how are you going to take action against Ronachuk? Because Ronachuk is not your company employee. So even if you refer this case to ICC and ICC conducts an inquiry and comes to the conclusion that Ronachuk is guilty of committing sexual harassment against Nija, how are you going to punish Ronachuk? You cannot dismiss him because he is not your employee. You cannot reduce his salary because he is not your employee. You cannot warn him because he is not your employee. Under these circumstances, when the respondents, that is, harasser, is not your employee, then the Act provides that instead of referring the case to Internal Complaints Committee of your company, rather refer this case to the Local Complaints Committee of the District Administration. You know what the District Administration does when the employee is not your company, the harasser is not your company employee. What the Local Complaints Committee does is it will file a case under Indian Penal Code, that is Section 509 of Indian Penal Code. It will file a case in the jurisdictional Judicial Magistrates Court, and the Judicial Magistrate Court will prosecute Ronachuk, and if he is found guilty, he will be punished under Section 509 of Indian Penal Code. Okay, so here we'll start our discussion on prevention of sexual harassment at workplace. And I thank you, all of you, for having joined this session. I enjoyed discussing this topic with all of you. I hope you have also enjoyed and learned a lot about this subject from this seminar. Thank you very much once again.